Good evening, everyone, and welcome to this evening's seminar on estate planning basics. Next week, we'll be actually following up with an in-person seminar with the advanced session. But for today, we'll be going through just the basics of estate planning, why you need one, what it involves, and all the rest. So super important to do. When I first started real estate, in the beginning years of real estate, our managing broker used to sit and do a training with all the newbies. And one of the things that he did, I still remember, is to go around the group and he said, "Do you have an estate plan? Do you have an estate plan?" And then he said, "Do you have property? Do you have children? Do you have anybody that you care about?" And he said, if you do, you need to have an estate plan in place. And that really stuck in my brain. At the time, I was in my 40s, early 40s. And so I went home and I was like, we need to have an estate plan. And my husband's like, we're still young. And I mean, no, we still need to. So it did take a few years, but we did get our estate plan in place. And I think it's just so important to do, just as I've gone, just met so many people in the course of real estate where they did not necessarily have an estate plan, or they didn't have that completely figured out or thought through or hadn't updated it. So many issues that came out as a result of it. And so I just really, we've done seminars on estate planning almost every year that we've been doing these seminars, because I think it is that important to do. So before I launch in, just a quick introduction. My name is Jean Zhou. I'm the broker and owner of Parison Real Estate. Parison comes from the Greek word for abundance and overflow. And our company's vision is to serve our clients, colleagues, and community so that everyone can really thrive. When I founded the company in 2016, my thought was to really base the company on this principle of abundance, and that we have received so many blessings. I have received so much. And so it's really incumbent on me to just be able to share out of that abundance that I have. And these seminars, which we've done ever since 2016, is really out of that sense of wanting to share, wanting to help other people to really have as much information as possible in order to be able to thrive as much as possible. A quick disclaimer before we begin: the seminar is being presented with the intent of providing information to our clients and neighbors. It's not meant to be construed as specific advice. So if you have any specific questions or any specific needs, this is hopefully to give you an overview, but really you need to consult with your attorney. John, who will be our speaker, is an excellent one, and then or your tax specialist before you do make any decisions. For this evening, as a quick outline, we'll be doing a market update. Just trying to I'm going to keep it very brief, but I am a real estate specialist after all. And so I do like to always start these seminars with just a few minutes of updating you on where the market is right now in our area. And then we'll go straight into the heart of our seminar and have questions and answers, and then announcements. I do ask that everybody keep yourselves muted except for our speaker, obviously, just so that we can there is a lot of material to cover, and we want to make sure that we get through it as much as possible. If you do have any questions, feel free to type them, put them into the chat, and then we'll take some time at the end to be able to go through those. And then if we don't have a chance to answer your specific questions, definitely we'll have a follow-up at the end. Follow up later, where you'll get the information for our speaker or for me as well, and then you can reach out to us directly with your specific questions. So as for the market update, the first metric that I like to use, if you've been to my seminars before, I always will cover a few different ones, and this is median sale price. It's the price at which you have the number of homes selling below it is equal to the number of homes selling above that number. So this is for single family homes in San Mateo County. And I'm not going to go into full detail on this, but this over the last 10 years. And you can see with all the ups and downs, you can almost draw a line from 2014 all the way up through this year, right? And then you have some peaks, especially with COVID and interest rates and all that's happening. Just to give you some idea of the numbers. So 2022, we hit an all-time high of 2.25 million. So this is about a year after, 2 years into, after COVID and all of that had happened, and people thought sky is falling, but we hit an all-time peak of 2.25 million. And then we had the interest rates, et cetera. this year in May, we actually hit another all-time another all-time high, surpassed that at 2.3 million. Since then, the market has gone down. The prices have gone down a little bit to over time, and May or April are usually the peak of our years to begin with. So as of August, which usually the mid-year is, will hit a little bit of a lull. And so in August, the median sale price did come down a bit to 1.78 million. If you compare that to August of last year, it's pretty similar because last year was 1.8 million. So not too bad, and we're still hoping for a good year as a good fall, especially as we're hearing news of interest rates starting to ease up a bit. In terms of months of inventory, this is to let us know how much we have on the market that's available, basically. And so from here, if you count 3 months worth of inventory, which is the peak of this graph, and that's pretty much where we've been capped for the last 12 years, is it has not really gone up above 3 months of inventory. So solid seller's market with some ups and downs. And then lately, we've been at around the 1.5 mark of months of inventory, which is still quite low. And so that's part of the reason why our prices continue to stay fairly steady, we're looking at between 1.7, 1.8 to 2 million and above in terms of our median sale prices. One of the biggest stories, biggest reasons why we have our prices remain fairly stable is the fact that we just don't have enough inventory. We do hope that that will ease up a little bit over time. And sometimes you'll hear that, oh, the inventory is increasing, but in our area, we're still quite low. And then the last metric, or the next to last one that I will use, is new listings. And so again, that picture of the new inventory levels, you can see here, this is over 10 years again. And so between January and December, you see a peak and then going down, because when we get to the holidays and whatnot, the number of listings does go down, new listings, as people hold off for the new year. But if you can see the trend for the last 3 years here, we are significantly below what we were showing in the previous years. And even in the previous years, we were low inventory, but now, and then specifically last year, we had very, very low inventories and started to see a bit of pickup earlier this year, but we're pretty much still staying around the same where we were. So we've always had low inventory. One of the biggest reasons that people are thinking of is that the interest rate impact is making it so that homeowners who have that nice 2-3% interest rate don't want to move out to, possibly looking at a 6 or 7 or 8% interest rate. And so it locks them into their homes. And as we anticipate that, the news is coming out and we're anticipating that the interest rates will start to come down a bit, hopefully that will free up some of that locked in inventory. And then finally, the interest rates. This is to give you an idea of this is going all the way back to 1971. This is from Freddie Mac and showing the 30-year fixed rate mortgage. As of last week, September 5th, we were looking at an average of 6.35%, which is really nice because we were seeing it inch up, and then at the end of last year, getting close to the 7s and 8%. This morning at my networking meeting that I host, we have one loan agent who shares with us, keeps us up to date, and he was talking about interest rates in the 5s. So that's nice to hear, a 5 in front of the interest rate, and that tends to be where the economists believe that will start moving things along a little bit better in terms of both the buyer demand as well as owners who are willing to sell and start making moves. So we're hoping, and we're going to keep looking to the interest rates. So inventory, interest rates, those are the two I words in terms of where our market is going to. And so now we're in September, and this is when we start seeing a little bit more of a bump again with the fall market, not as big as the spring market. But hopefully that, coupled with the interest rates, will be able to help us have a good fall moving ahead. So with that, I'm going to launch right into, I'm going to go ahead and hand the reins over to John C. Martin, attorney, who is going to be speaking with us about estate planning. So bridging your future, what is estate planning and what do I need to do?
I am John Martin, certified specialist in estate planning, trust, and probate law. My office is in downtown Palo Alto, and I've been helping clients for 16 years transition their wealth to the next generation or to charities, and doing that while minimizing expenses, taxes, claims, preserving the lives of their beneficiaries, their loved ones, and also thinking about their incapacity. So we can go to the next slide. That's what that says. So we'll go to the next one. And I wanted to introduce just basically what estate planning is. And then as we go through this presentation, we talk about basics, right? So we're going to talk about some things that have happened in my practice, some real life stories. And we're going to talk about why people plan, what motivates them to plan. And we're going to talk about that both from just the plain wills and trusts world. Why do people need a trust versus a will? When would they need a trust versus a will? What about joint tenancy? Can you get away with that? And then we're going to look at some specific client situations where somebody had just a really basic, plan. Maybe they just scrapped it together themselves. And then what are the things that went wrong or that would go wrong if they passed away or became incapacitated with that basic plan? And then I'm going to show you how having some good estate planning put in place will help them with that. So that's what we're going to do. So you start with, hey, what are estate planning decisions all about? It's really three essential areas. And I already said it, so I gave the surprise away. It's about transferring wealth to the next generation. It's about protecting your beneficiaries. It's about incapacity planning, and we're going to now distill that. We're going to go through that. So next slide. So I mentioned that as we're going through there, I'd like to share where things go wrong. And the reason why I do that is because you ever heard that it's good to make a mistake? So I learned this in school that, you actually end up remembering something more if you mess up, and you hope that you mess up in your homework, right? And not on the test. So think of this like your homework, right? And if you've done something, one of these things, or you know of somebody who did something, and then you're like, oh, shock, and the horror, like I have a friend and this happened to them, then that can be a great motivation for you. And it's one that you're not going to be harmed personally by, your family's not going to be harmed by. You're being informed by it. My parents used to say, do as I say, not as I do. So if we go to the next slide. So one of these is just the thought that you're going to live forever. My wife and I have decided we're going to die in our 90s. And we're going to both die at the same time, and we're going to die holding our hands, each other's hand in our sleep. And it's a great, wonderful thought. We both know that that's not really true, right? Even if we did live a long time, the thought of dying, at our own terms is just kind of ridiculous, right? We know that mortality happens. We know that life happens. And by the way, can I just call out that that's an awkward thing to talk about? But it's what I talk about every day because it's so important. If somebody's not going to talk about that, when are you going to talk about it, right? So a lot of people do think, and we have a lot of smart people in this area, I'm going to live at least X number of years, so I don't need to do this today. I will do it tomorrow. Next slide, please. You don't know, though, when you might have a sudden incapacity. You know that there are many different things that could happen that could lead to a sudden incapacity. You can fill in the blanks, but stroke, heart disease, an accident, car accident. So think about your loved ones. I had a client whose husband became incapacitated after a motorcycle accident. He was in his 20s, right? And he ended up passing away. She's in her second marriage. That was not predicted at all. Next slide. So you want to think now about these things. These are hard subjects. It's hard for couples to sit down in my office and talk about what if one spouse dies before the other and the surviving spouse remarries. Very awkward. And I don't suggest you go home and, talk about that every night. But maybe one time in the attorney's office could be the difference between your kids inheriting what you've worked so hard to build up for them. And then naming people. A lot of people think that's really easy. It's actually not so easy, but it's very important to name the right people who are going to make care decisions for your kids or for each other. Next slide. So I mentioned you don't know when the incapacity or the death might happen, right? So you think about this as your planning window. When's your planning window? It's between now, today, and your mental incapacity. I get these calls pretty often. But last week I got a call. There's somebody in the hospital. They didn't do any estate planning. They want me to come and go to their bedside and to do a plan for them like now. I have no idea what when I'll try to do that as an attorney. But if I go there and they're like, it's not clear that they know who they are, it's not clear who they know, who's they're leaving assets to, they can't do a will. And if they don't have the ability to manage just basic financial transactions, they definitely can't do a trust or power of attorney. So, and that's what we're talking about tonight. And that's either because they put it off, or because something suddenly happened, right? So it's between now and this mental incapacity. And then after that, these documents, and I put down here trust and power of attorney, and we'll talk about those. But that's when those kick in. That's when those start to become effective. So you set them up before you need them. Once you need them, it's too late. Then you're in court conservatorship process. So next slide. So a lot of people say, well, I have a will. And, sometimes it's attorneys that say this, people who should know better. Maybe they wrote it out, and they put it in their desk drawer and they're like, well, I went to law school and I know that that's legally effective. Or I named my child on my deed. Or, hey, I just have some bank accounts. I'm just going to have them pay on death and that'll avoid probate. My estate plan is in order. Next slide. So the problem is that there can be a lot of changes that happen. Joint tenancy, you don't know the order of deaths. What happens if the person who's a joint tenant passes away before you? What happens if they get sued? You might end up losing your home because of the joint tenant you named on your home because you thought you were avoiding probate. Next slide. So we want to create a plan that's going to go beyond just your best assumptions, your best guess about what might happen, that takes into account the changes that might occur in the law, in your family situation, in your asset situation. And then we want to revisit it regularly. So we think about what happens if you die within the next 5 years or become incapacitated. Let's really cover a lot of contingencies. And then we also want to continue coming back and updating that plan over time. Next slide. So another problem, another mistake we see is people know what I want. They know what kind of decisions I want. I hear this all the time. My husband knows that, I should be unplugged if I ever become in a vegetative state. Can I go to the next slide? I actually have a cartoon on this. It's a little bit small, maybe on your screen, but there's two people sitting in front of the TV screen. The husband says, you know that if I ever am in a persistent vegetative state, that you should unplug me, right? And so, of course, the wife promptly unplugs the television. And this is because things can get lost in translation. Did you know, the most famous case about this, Terri Schiavo, right? Her husband disagreed with the parents. Husband says she always said she wanted, life support discontinued. Parents said, no, she always said she wanted to just keep on fighting. So which one was true? Maybe both were true. Maybe she said both at different points in her life, but she never wrote down something that was going to be legally effective. So the Supreme Court, the president, the Congress had to all get involved in that young lady's life. What a tragedy. Go ahead, next slide. So we want you to write down your own documents. In our society, it's really all about what do you want? And if you can say it in the hospital, great. If you can't say it, we want you to say it in advance. And this will take something off the table for your loved ones. Stress is about not knowing what's going to happen next. If you can take something off the table for them, it makes it so much easier. And then you lower the temperature, and there's going to be less disagreement among your family members about different things like who gets what in the estate. Next slide. So another one will be, hey, I'm married. And so everything's going to go to my spouse automatically. So I don't need to do anything fancy. Next slide. So that may be true, but what about, did you know that if you have separate property, that actually will not go automatically to your spouse? It gets split between your intestate heirs and your spouse by law under the probate code. People don't realize that. They think, well, everything will go to my spouse. Your one half of community property will. Your other half of community property would be split between your intestate heirs and your spouse if you never had a will. So it's important to write down where these assets are going to go. People's assumption, oh, it's all automatic to my spouse or all automatic to my child. Not always. Sometimes there's a rule you were not aware of. Let's say you did have a simple trust or will all to your spouse, right? And then all to your kid. But then your spouse, you die first and your spouse remarries and there's new kids. Or there's a 20-year remarriage and conversations happen over the course of 20 years and your children get disinherited. I see that happen a lot. Maybe that sounds weird. Like, why would anybody disinherit their kids? Second marriage situations, a lot happens over the course of that. The emotional dynamic changes. Your loyalty to your new spouse changes things, right? And that's the person you're aging with. So it can be a very big emotional pressure. Next slide. So we want to think about how can we plan for these future events so that your expectations are not going to be dashed based upon these changed circumstances. Next slide. And same thing with leaving everything outright to your children. Next slide. There's issues with that. Most obviously, you're not an adult able to consent, able to receive an inheritance until you're 18. So if you have a trust or a will that just says, give it to my kids, and there's no trust that manages that for them, there's going to have to be what we call a probate guardianship for those kids. It's very expensive. There's reports that go to the court all the time. There's a bond that gets posted, and it's public. People can see what your kid is receiving in their inheritance. And there's not a lot of flexibility in the kind of investments that can be chosen for those kids. So we want to be able to avoid that. Plus, what happens at 18 when they get their money? Are they going to be mature enough to handle it? So, in basic estate planning, we want to think typically about delaying that and then thinking about real life specific and general risks that might apply for that child. So do they have special needs, right? Are they really immature even at 20, 25, 30? Are they going to need some third party to manage this for them? What about general risks? Because every time I fire up my car, there's some risk that maybe there's a car accident. With every marriage, there's a 40% risk of divorce. So you, as a potential, giver of this asset to your child, you can plan for that. And you can plan for protecting these assets for your kids, either to get them to a stage of maturity, to deal with a specific risk, or to just plan for these general things that happen in society. Next slide. And I think I mentioned that a little bit, but we do have options in the ways that we can handle it. Next slide. Another one would be relying on the default probate rules. Next slide. So I already mentioned that there's rules that might, be surprising to you, like where your separate property goes. But probate, and this really shocks a lot of people, especially who are not from California. My wife's from Maine. I found out probate takes a couple months in Maine. Do you know how long it takes in California? In Santa Clara County, where I practice, it's taking about 2 years to go through probate. So imagine waiting 2 years to get your inheritance. Next slide. Plus, it's really expensive. So you're paying a lot of money in probate fees. It could be tens of thousands of dollars, hundreds of thousands of dollars for some of the clients that we see coming through our office. Plus, you're heightening the level of risk in getting a lawsuit because you have to notify all your creditors. You have to publish notice in the newspaper of the death, and then they come after you and give all their claims. Next slide. Plus, what about your arrangements for burial, for cremation, for funeral? Have you specified that? It's not specified in the probate code by default. Who's going to handle that? You need to think about appointing somebody to do it. Next slide. Plus, there's this long process of gathering assets into the estate, inventorying them, getting a probate referee to go in and to value assets. Very long, very expensive. Next slide. You have to pay off all these debts, and it's mandatory that you do it. So there's this creditor claims process. A creditor files their claim. If you don't satisfy that debt, there's this attorney fee shifting that happens. So you have to pay the other side's attorney's fees if they have to sue you. Next slide. You have to file tax returns for the estate. So there's estate income tax returns. And then you have to get a judge to sign off on the distribution of the order when you're going through the probate court. Next slide. So this is very rarely what people want. It's kind of like a lawsuit people are filing against themselves where their assets that are satisfying the judgment for that lawsuit. I mean, really a nightmare. Next slide. So wills will still have to pass through probate. A will is not enough. So when people say, what's the difference between a trust and a will? We start with this, right? Will is great for designating where you want to leave your assets at your death. They're great for designating who you want to be your executor, the person to make decisions, right? They're great for naming the guardians for your children at your death, but they're not effective for anything else. So they're not effective for managing your assets while you're alive. They're not effective for having guardians while you're incapacitated. They're not effective for incapacity management of your assets. And of course, they don't avoid probate because all the assets that are in the will still, you have to prove the will in this court process, go through a lengthy, expensive process. Next slide. So let's go to the next slide. I think I've defined that. I've defined that as well. Go ahead and the next one. So what goes through probate? This is really important to know. It's your probate estate. So there are some things that don't pass through probate. Life insurance with a beneficiary, retirement plans, joint tenancy assets, pay on death accounts. If that individual joint tenant, pay on death beneficiary or life insurance or retirement beneficiary survives you, right? Because otherwise you're still going to be going through probate. But trust also avoids probate. A trust is just a legal entity that you're setting up. And we'll get to that in a little bit more detail. There's also things that are outside of your estate. Maybe you gifted something to someone, right? You wrote a check for $5,000 to your child. That's not going to go through probate because it's owned by your child now. Or you set something up in a trust that's out of your estate, an irrevocable trust, which we won't talk about in detail today, but we'll just touch on it lightly. Next slide. And we've talked about this. You're really losing control. Things are really expensive. There's bond. Next slide. And I mentioned tens of thousands of dollars. This is all set by law. So, people say, well, how can this be? How can it be so expensive? It's the system, folks. They wrote the laws, the attorneys wrote the laws, and then the attorneys are going in and administering this for people, and they have a fee. It's all guaranteed. And you know that they get paid before the bank gets paid, right? They put themselves highest in priority. That the attorneys doing probate get paid before everybody else, before the hospital, before the bank, before your credit card, before everything. It's the attorneys because they were the ones who wrote the law, right? Now, if I'm sounding a little bit like cynical or whatever, I also call this welfare for attorneys because it's kind of easy, but they keep it just complex enough where like lay people can't figure it out. Because the forms, when you're first looking at it, you get really overwhelmed. There's all these hearings. You don't know how to file for the hearing. So the judge is like, you should hire an attorney. But for an attorney, it's very easy work because you're really just filling out forms. But you want to avoid this. Go ahead and next slide. There's also what we call probate, a living probate. So that's conservatorship. If you don't do a healthcare directive, you don't do a power of attorney, you don't have a trust, you may end up in living probate. Go ahead and next slide. So where your loved ones have to go petition the court to go open up a case to manage all your personal and financial affairs. Really awful, right? Because then we've got to prove that you're incapacitated and there might be some dispute. Gets really expensive. We got to get these doctor's letters filed. There's a declaration that gets filed. Bond has to be posted. Sometimes there's confusion over what the powers of the conservator are, and it never ends. It's permanent. And then the judge is always, signing off. There's an investigator's office that looks into it. They write this huge report. It's just a nightmare. Next slide. You lose control because now there's a court-appointed conservator who's making decisions for you, and it's just the default probate rules. And maybe it's somebody appointed by the court and you had no say over who that was. Next slide. Yeah, next slide. So let's now transition to talking about the document that, remember, we looked at your planning horizon, and the trust was like along that entire field, right? It was now it's effective, at incapacity it's effective, it's at death it's effective. Because we think of a trust as like the master document, the most important document, the most foundational document to estate planning, because what it is a legal entity that you're able to set up to hold your assets. And it's also an agreement that you're establishing to indicate the terms by which all your assets will be transitioned at your incapacity, at your death. So you're going to be the beneficiary of that now. At some point, the beneficiary is going to change right at your death. And this document, it's like all of those different trigger points. When does this person handle the bills if you're incapacitated? What do they pay? What do they not pay? How about at death? They handle certain taxes and claims. Let's give them discretion over where they pay the taxes from, right? Or let's have them do it all equally, no matter where the gift came from. It came outside of the trust from life insurance. They still have to pay their fair share. So lots of different instructions that are going to be in there. You could also think of it like a piece of furniture, because within the trust, there's going to be different drawers or different sub trusts that get established at a future point. So you've got the main trust now, or the family trust, or the living trust, and that's for you today. And then at your death, maybe it's going to be a marital trust for your spouse, or at your children's death, like a common trust for all your children, that it's held for them while they're young. Next slide. So another way to think about this is kind of like a funnel through which all of your assets pass from you on the way to getting to the beneficiary. I also tell people it's kind of like a company. So you think about Coca-Cola. Warren Buffett's a big shareholder of Coca-Cola. If he dies, and it's probably not going to be too long from now, Coca-Cola will still be there, and it will still own all the same property that it owns. He'll no longer be a shareholder. It'll be somebody else. So same thing with your trust. You will no longer be the beneficiary. Somebody else will be. The trustee will also change. Next slide. So here's that dresser, right? So you've got different sections of the trust dealing with different periods of your life. And it also reflects a lot of your values, your hopes, your dreams for people, because you can express what you want the property to be used for or not used for. Of course, it avoids probate. It minimizes the chance of dispute, lowers the chance of a lawsuit, because there's no creditor claim process. There's no obligation to notify anyone. There's no obligation to publish anything. It's completely private, right? And so your family is just able to administer this estate in the privacy of their home, maybe with the help of an attorney or CPA. Next slide. So how do these documents overlap, the will and the trust? So I still have our clients do a will, because what if you leave assets outside of the trust? You still want to make sure that those pour back into the trust at your death. And also, we might have certain provisions under the will that don't go under the trust, like naming the guardians. And then the trust is going to have certain things that happen after your death, like maybe there's going to be charitable gifts, there's going to be disposition of tangible personal property, there's going to be provisions dealing with life insurance. Next slide. If you think about traditional wills, they're going to deal with just going through probate, right? Whereas assets outside of the probate process pass automatically. Next slide. Let me just finish that in a trust, you're able to avoid the probate process. And typically we will coordinate, we'll have beneficiary designations pair with the trust, so we can get as much in the trust as possible, including things like life insurance, or accounts that, like stock option accounts that can't be put into a trust during your life, but we can have them pay into the trust at your death. Okay, so I wanted to share a story about how good planning made a difference in somebody's life, a real life story about a client of mine, and how a trust helped them go through a bankruptcy that occurred. Because we've been talking about specific general risks, right? I would say that the possibility here of this risk was a general risk that the parents could not have foreseen. So I'll show you how this worked. So I helped married couple with estate planning about 10 years ago. And then a few years after that, the wife, her parents died, and they left her a couple $1 million. It's great. Thank you, mom and dad. And they left it in a trust for her, right? So we've been talking about how you can protect assets in a trust. And she was actually trustee of her own trust. So she has the ability to pay bills, to manage her own trust, right? Sometimes we call that a self-directed trust because she's trustee of her own trust. She gets the benefit of managing her own inheritance. There's no restrictions really on her because she's her own trustee, except that the funds are in the trust. So then they came, this married couple, to me, and they said, the husband said, I think my in-laws just didn't love me. They just didn't love me. They thought, I just was going to eventually divorce. I don't know. And I think they did this because they didn't love me. And I said, you know what? I don't think it was because they didn't love you. I think it's because they really loved your wife. And I think they were thinking this would protect her in case something happened. And it's not just divorce. There's also bankruptcy. There's creditor claims. There's lawsuits. Things can happen. Things can change. So I think there's a benefit of this trust. And so he kind of changed his tune. He's like, that's right. I think you're right. And there's some other benefits. Okay, so some time passed, and actually the COVID pandemic hit. Now, this gentleman was running a restaurant, and I won't say what town, but it's a local town in the peninsula here. And his restaurant really had a hard time during the pandemic, like a lot of restaurants did. This couple ended up going through a personal bankruptcy. So in a personal bankruptcy, there's an estate opened up, and then a trustee will collect all your assets, and then they'll satisfy your debts unless there's any exemptions, and you lose your assets, right? This $2 million trust that we were talking about was not part of the bankruptcy because it was protected for this lady. They ended up losing everything else, and then they ended up moving to a different state. This is their retirement. This is the only asset that they have left, is that inheritance. So I think that's pretty powerful and can show the benefit of trust planning. Next slide. So another story is I had a client, and I did some planning for them, some estate planning. It turns out that he had cancer, and he was declining actually really quickly. Nobody had said you have to stop driving, but he's feeling really weak, feeling really tired. He hit somebody. And actually, this person ended up going into a coma, and having really serious injuries. And there was a lawsuit, and you know how much they were seeking? $22 million in damage. I say don't hit anybody, right? But definitely don't hit like a 25-year-old venture capitalist, because you don't know who you're going to hit, right? And especially in this area, it can be very expensive. And some people say, well, I've got car insurance. Well, it's very unlikely that you've got $22 million in insurance. People get a personal umbrella, right? But the thought that this is what lawsuits right now in California, you're seeing people getting damages awards of vast amounts of money. It's not just like 1 million or 2 million or 3 million. It's tens of millions of dollars. And so this couple, they had saved and worked hard their whole life. And they built up an estate of about $10 million, right? Just such hard work, right? And so this guy left a surviving spouse, and it's just so sad to think that she would have nothing to be able to leave to her children. But thankfully, we were actually able to go through a few steps that were able to shield her from a big portion of that estate. And that was by setting up a marital trust for her, which is asset protected. A marital trust, or a Q-tip, actually has some great asset protection benefits because it's shielded from estate claims. And so this has provided huge comfort for her, knowing that at least the portion of assets which has passed into this irrevocable trust is going to be exempt from judgment liens and creditors. Again, a story about how these changed circumstances, but good estate planning can really make a big difference. Next slide. So now I wanted to go through some specific examples of how we've been able to help some people. So we have this client with 3 kids. Next slide. Their assets, they've got their home here in the area. And by the way, I changed the names, but these are real life. This is a real life client with real life numbers. So a $5.5 million estate. And this is how they came to me initially. Go ahead, next slide. They had just basic wills that went to each other and then to their kids. So let me show you. So I'm sure people are thinking, wow, what did John just mention? Probate guardianship for the underage kids because they don't have anything to hold their inheritance until they're 18. What about maturity issues, right? What about remarriage issues? Taxes, not a problem because, state taxes only kick in at a higher amount. Probate, they're going to have to go through probate. There could be creditor claims. There could be a lot of these things. So a lot of the stuff we were talking about. And of course, what about incapacity planning? What about healthcare directive? What about those sorts of things? Have they thought through all their wishes? Next slide. So the estate plan that we came up for them with was to have a survivor's trust. And part of this was counseling. How much do you want to guarantee that your half of your community property, when I say CP here, that's community property, separate property is SP. How much do you want to guarantee that that will pass to your children of this marriage if you were to predecease your spouse? And some people say, you know what, I'm not really that concerned about that. Let's just leave it outright to the surviving spouse. That's what we did here. We created a disclaimer bypass trust because at a $5.5 million estate, and I see a lot of people, in our area with a house, and retirement accounts, and they're a little bit over that $5 million threshold, which when we have the law expire in 2026, we're going to have that $5 million estate tax threshold that comes out again. And so a client like that, even though they're not affected today, they should still think a little bit about estate taxes. So we put in a disclaimer trust so that they can actually shield a portion of their estate from estate taxes. If that ever becomes a law in the future, the current law expires as planned in 2026. And then we set up a common trust for their kids because their kids are pretty young, right? And common trust is great because you're able to pool the inheritance in one trust. So rather than three different trusts, which means three tax returns, three accountings, three different accounts where you're handling everything. Said now you can have one trust. If they both passed away today, they could keep the home, they could keep all the accounts aggregated. You're lowering the cost of the administration, and it can terminate when the youngest child reaches a certain age. It's a pretty basic plan for this family, but we're solving all of those issues that I just mentioned, right? The probate, the privacy, getting the kids launched to an age where they're sufficiently mature, and then dealing with the potential estate taxes, dealing with the retirement plans, life insurance. Next slide. So another one that I had was this young lady, and she's a single mom. Her estate's much smaller, and she has a son who's autistic, and her estate, is pretty illiquid. She had some retirement, and the problem. Go ahead and next slide. Problem with this plan that she had, which was, nothing, but I put in here, simple will or joint tenancy. Maybe that was the idea that she had of something that might bypass a trust, but actually she had nothing. But the thought was, hey, there's a big risk here because if your son has needs-based government benefits that he's going to be taking in the future, he's going to be disqualified from those. If he's going to be receiving distributions from your retirement plan, the house won't disqualify him. But if he's getting that income, he's not going to be able to qualify for benefits. So next slide. What we did was we set up a special needs trust for him under their estate plan. We advised her to get some more life insurance. She's pretty young. She should be able to get some great rates. Make that payable into the son's special needs trust so that there's going to be enough resources for him. And actually, we had the IRA go to a different place, so it wasn't going to be there causing extra taxes in his special needs trust because trusts pay a lot of taxes on income more than individuals do. And so we had that go to her charitable beneficiaries and some other family members. Next slide. So another final example is this married couple with a larger estate, but they're blended family. So he had a couple kids from a prior marriage, and then they have one shared child from their marriage. Next slide. So they had also an estate plan that was pretty basic. It was just all going to each other. And they weren't taking into account, hey, what if the law changes? What if we need to get both of our exemptions counted to avoid estate tax? Next slide. So what we did for them was we set up a marital trust. A marital trust can preserve the estate of the first spouse to die, and we can divide up where each spouse's estate is going. So Wendy here, if she's the surviving spouse, her survivor's trust is going to pass to their child of their marriage, so their shared child. Whereas Harold's property, which goes under this marital trust, is going to pass to all three of his kids. But Wendy still has access to that marital trust while she's alive. She can draw upon it if she needs the money. And maybe Harold will name, a child of his or a sibling or somebody or an independent trustee, somebody who's disinterested, to help make sure that those rules are going to be followed on that marital trust to sign off on principal distributions. And then we know that Harold's two children from his prior marriage are still going to have an estate, even if Wendy survives him. And plus, we put in some great estate tax planning there so that they can do what's called a portability election, which is a seamless way of reserving your deceased spouse's unused exemption and avoiding estate taxes at the second death. Next slide. We also added in this one trusts for those children. Remember, I was mentioning my bankruptcy story. So we added in this estate plan that each of their kids, Joe, Sally, and James, were going to be able to have their own trusts. And it was a big enough estate where we felt like that was a great benefit for them. Few $1 million, and then having the possibility of divorce, creditor claim, lawsuits, bankruptcy. Yeah, I think that's worth it to make sure that your inheritance stays with your kid. Next slide. There's also advanced planning tools that are out there when the need arises. Next slide. So I would encourage everybody, go home, think about these horror stories, think about what it is, and don't, stay up at night after night, thinking about it. Instead, just make an appointment and do something about it. Next slide. And your end result is going to be peace of mind. So that's my presentation. And I'm happy to take questions in the Q&A if we have time.
Yes, we do. Thank you so much, John, for that. And hold on, let me add. Yeah, so thank you very much. Do we have any questions? I'm not seeing anything right now in the chat. I think it's if anybody has any questions they'd like to ask, or I think everything was too clear. John.
I guess so. It was so crystal clear that
It was so
no
crystal clear.
questions.
Well, I think the main takeaway for me is you have to talk to an attorney, like go through every situation and find out what the specific things are. I have there's somebody that I know who is one of my clients said, oh, I pretty much I already have it all written up. I just need somebody to maybe help me record it and check it. And but going through, as you're going through it, it's like, well, there's a lot to think about, right? And a lot to there are a lot of different considerations that maybe we haven't thought about. And so it might mean it's more than just a simple, well, there's a lot more that can be complicated in there.
How long does it take to set up a trust?
Okay, well, typically we take a month and a half to set up an estate plan. So a trust, power of attorney, healthcare directive, HIPAA, authorization, general assignment of your assets. And the reason why it's not just like that is we take some time to review assets, to review family situation, and we have 3 meetings, right? So we start with just initial goal setting, framing the conversation, framing the asset information we're going to look at, and then we go over design. So we go over different ways that the estate can be set up. We talk about real life scenarios like, hey, this is your family situation. Here's where I've seen something similar. Here's what happened. And then we draft documents, there's review, and then we come back, we review together, and then you're signing. And then we say, hey, continue to come back because the law will change. You'll buy and sell assets. Your kids will grow older. You'll have grandkids. Things are going to change. Like kids will get married. Their marriage will be great. Sometimes things happen. And so you want to stay in touch.
So,
Right.
and what's the general cost for that, John? Like people can expect if they're.
It does range
Mhm,
based on the complexity, but people are looking at about like $4,000 or $5,000 for that core, what we call core estate planning, which is that host of different documents and the counseling that goes into creating them.
And if somebody, how about for updating? So how?
Well, let me share with you because every attorney is a little bit different.
Mhm,
But what I offer my clients is a client care program. So when they're signing their trust,
mhm,
um, we offer them storage of their original will and trust immediately. We sign them up for a emergency contact card so that they have cloud storage of their documents, a web address, my phone number, where we're able to respond. I've been called by the hospital. We get the
mhm,
emergency directives to the hospital floor if need be. And so at their 1 year anniversary, we invite them to join this client care program, which we charge, 675 per year for a couple and 575 for a single individual. And it includes an annual meeting, word processing updates to their documents. So the document is on my word processor. I can go on it. I can make changes to the order of names, changes to percentages, so these basic changes. And then that annual meeting, they can bring their kids, they can bring their financial advisor, bring their CPA,
mhm,
and then we're going to spot issues that maybe would have never come up had they not had that kind of regular review. Now, some people get that and they end up meeting once every 3 years rather than every year. That's fine. But we just want to have some kind of regularity
mhm.
so that people are coming back. And then when people don't opt to join that plan, and that's fine, we just charge an hourly rate to update documents. And of course, it just ranges. And right now it's $5.95 an hour.
Okay. Well, that sounds like a great program, though. I hadn't heard of
Yeah.
that. So that's really good. That was going to be my next question, which is how often should, somebody look into updating their estate plan? And so that's great to be able to have that kind of a service available. And then if somebody has an old estate plan and they come to you, is it just pretty much from scratch that you're working, you would say, or how how do you usually handle those?
Okay. I mean, we get people who've done estate planning for themselves for decades, right?
Mhm,
And then we get people who are starting from scratch. We get people where we look at the estate plan, it looks great, and they've kept it up to date. And maybe we're just doing a very narrow thing, and we can do that. But where I start is, hey, what are your goals? What are your assets? What's your family situation? Does this document that you gave me line up with that? Because I can see a document and it looks great. And maybe it creates the marital trust that I described. And that locks things in at the first death. And then I talk to them, I'm like, oh yeah, do you want to lock things in at the first death? No, I want it to be all up. Okay, well, you have a marital trust under your trust. So maybe we should eliminate that. Like, oh, nobody ever asked me that. I just kind of assumed that it did something else.
mhm.
So I think if you don't have that voice of reason telling you your document does this, are you sure you want that? So I do that a lot. I point out what the document actually does. And people, they look at it and they're like, it's all Greek to them, right?
Yes.
A lot of it's legalese and it can really confuse people. And I'm just very no nonsense. I'm like, this is what this does.